Good afternoon, everyone. My name is April Walker. Thank you so much for joining us today. Before we get started with today's webinar, let me quickly cover a few housekeeping matters. First, all attendees have been muted. If you'd like to minimize the GoToWebinar dashboard on your screens, feel free to click the orange arrow on the right side of your screen. Several questions were submitted during the registration process. We do plan on addressing a couple of those questions before we adjourn today. However, if you have questions during the presentation today, please submit them using the chat feature, and today's presenter will answer your questions by email after today's webinar. And with that, we'll go ahead and begin. Upchurch, Watson, White, and Max Mediation Group and the University of Florida Levin College of Law Institute for Dispute Resolution are proud to co-sponsor today's webinar entitled Lawyer Professionalism as a Tool for Successful Negotiation.
Good morning, ladies and gentlemen. April and I hope you're having a good day. Hopefully we'll be able to add to that a bit. We're going to provide today insight into an area that we think will make your job as lawyers and negotiators easier and more rewarding in the future. Share with you some of the tools of the great negotiators. And we'll have more to say about that in a moment. Today, we're going to really discuss professionalism and negotiation from two different perspectives. Professionalism, I firmly believe, is the heart and soul of negotiation. As a mediator, when I get to a mediation, if I find out, and usually I find out very early, that the lawyers are professional, the parties are professional, then I know we're probably headed toward a successful mediation. So we're going to discuss it, as I say, from perspectives. We're going to start with an overview of professionalism in Florida. I don't know that all of you are attorneys, but certainly I think whether you're an attorney or not, it's helpful for you to know what professionalism is, how we got here in Florida, and something of the structure of the governance of professionalism. So we'll start with that, and then we're going to get into some practical negotiation techniques that arise from professionalism. Start with sort of a basic principle. As you see there, while the canon of ethics may cover what is minimally required of lawyers, professionalism encompasses what is more broadly expected of them, both by the public and the best traditions of the legal profession itself. This is a quote from the ABA Commission on Professionalism Study and Report from 1986. How did we get here? Prior to 1986, the term professionalism was really nothing more than a speck on our horizon of our lexicon. I began practice in 1971, and I don't really recall hearing the term professionalism much until about the mid-1980s. And what happened is this: in 1986, the American Bar Association Commission on Professionalism produced a study and a report that showed that a great many lawyers were becoming increasingly dissatisfied with the degree of civility and professionalism in the bar. Hard on the heels of that, in Florida, from shifting to the Florida perspective for a moment, we had an early article called Professionalism, Let's Keep It Alive by Patrick G. Emanuel. Patrick was a Pensacola attorney who, for anyone who ever knew him, exhibited a high degree of professionalism. 1987, we had another article, Professionalism, a State of Mind as Well as Behavior, by Ray Ferrero, Jr. And in 88, we had Professionalism, What's That, by William Reese Smith, Jr. The 1998 article by William Reese Smith sort of became an early pioneering article because, as we'll discuss in a minute, it proposed 3 elements of professionalism. In 1990, the Florida Bar adopted the ideals and goals of professionalism. So you can see the progression very quickly. We're moving into a greater recognition of professionalism as a subject worthy of consideration. 1993-1995, the Florida Bar commissioned 2 separate attitude surveys of lawyers, and they showed essentially what the ABA Commission report had shown earlier, and that was that lawyers were increasingly unhappy with the level of professionalism in the state. So in 1995, the Florida Bar created the Standing Committee on Professionalism. Keep in mind, this was created by the bar, not the Supreme Court. As we go through this, you're going to see that some committees, some commissions were created by the bar, some were created by the Florida Supreme Court. In 1996, the Florida Supreme Court created the Commission on Professionalism and the Florida Bar Center for Professionalism. The Florida Bar Center for Professionalism was renamed in 2005 for Henry Latimer, who was an Afro-American judge in South Florida who had been very interested in professionalism over his career. Then in 2013, 14, and 15, which is really pretty close to us, the Supreme Court, by an administrative order, created a code for resolving professionalism complaints at the circuit level, and we'll talk about that in a minute, created circuit panels, and in essence came up with a procedure for resolving informally professionalism complaints. So right now, this schematic may be helpful to you. You have the Supreme Court Commission on Professionalism and Civility, which was created by the Supreme Court's administrative order. Then you've got the Standing Committee on Professionalism and Civility, which was created with the Florida Bar. You have the Henry Latimer Center for Professionalism. You have the Circuit Court Professionalism Panels. And then you have the Attorney Consumer Assistance Program. First, the Supreme Court Commission on Professionalism and Civility. First, you should note that "and civility" was only added to the name last year, 2017. Prior to that time, it was just the Supreme Court Commission on Professionalism. There was a fair amount of discussion in the Standing Committee and the Commission as to whether civility should be added. There was one school of thought that civility was already encompassed in the term professionalism, and therefore adding the words "and civility" was unnecessary. But in any event, that was added, and since 1917, that's the name of the commission. The best way to think of the Supreme Court Commission on Professionalism is that it is a policy-making commission created by the Florida Supreme Court. It serves as a steering and long-range planning commission for the creation and implementation of programs promoting professionalism. It also oversees the development of judicial professionalism programs and the promoting professionalism in law schools. Commission right now has 36 members, and Florida Supreme Court Justice R. Fred Lewis is the chair. Standing Committee on Professionalism. Standing Committee on Professionalism was actually created in 1995 by the Florida Bar. But in 1996, when the Supreme Court created the Commission on Professionalism and the Henry Latimer Center, it really delegated to the Standing Committee on Professionalism an adjunct role in assisting the Commission. So right now, the Standing Committee on Professionalism is to assist the Supreme Court Commission and the Center for Professionalism in implementing the programs, events, activities to promote professionalism throughout the state. The committee was responsible for drafting the Code of Professionalism Expectations, which you may or may not have heard of, but it was approved by the Florida Bar Board of Governors effective January 30, 2015. I am in my 5th year of service on the Standing Committee on Professionalism, and I participated in the drafting of the Code of Professionalism Expectations. The committee presently has 48 members. The Henry Latimer Center for Professionalism. It really it does so many things, it's hard to say, but the center has some full-time employees. It coordinates all the Supreme Court Commission activities and the Standing Committee on Professionalism. For instance, when I go to a Standing Committee on Professionalism meeting, the director of the Henry Latimer Center is there providing assistance to the committee. The center serves as a clearinghouse for research and information. It provides staff support for activities, serves as research, writing, and teaching resource for professionalism. In effect, it provides as a giant library for all things dealing with professionalism. And 3 times a year, it publishes The Professional, which is a newsletter. It's a digital newsletter that focuses on professionalism in the legal profession. I urge everyone who is listening to this webinar to Google Henry Latimer Center for Professionalism. You can also get to it through your Florida Bar homepage. But you will find a wealth of material. For instance, all the administrative orders that I'm talking about today, numerous articles, anything you can think of on the subject of professionalism, you can access through the Henry Latimer Center's website. And I urge you to do it. It has a lot of very interesting information. The Circuit Court Professionalism Panels. In 1998, the Supreme Court directed the Chief Judge of each circuit in the state to appoint local circuit court professionalism panels, and they did that. And the panels acted generally to try to informally resolve professionalism complaints. But by an administrative order June 6, 2013, the Supreme Court actually formally assigned to the circuit court professionalism panels the duty of informally resolving complaints. The members continue to be appointed by the chief judge of each circuit. And when a complaint comes in to the local panel, the panel attempts to resolve it informally if possible, or it can refer it to either the Attorney Consumer Assistance Program for further action, or on to the attorney for the Florida Bar if the breaches rise to an ethical breach. The Attorney Consumer Assistance Program, which was also created by the administrative order in 2013, is really an intake and screening body It fields and screens complaints against members of the Florida Bar. If you are a member of the public, you're most apt to be aware of the ACAP rather than the local panel. And so that's typically where a member of the public goes to lodge professionalism complaints against a bar member. Like the local professionalism panel, the ACAP can attempt to resolve the matter informally, can dismiss it, or can refer it on to the local panel. And like the local panel, it may choose to refer it on to the Florida Bar attorney for what other action may be necessary. Standard of professionalism. The Supreme Court in that 2013 administrative order also created a standard of professionalism. And it did that by adopting existing creeds and codes. You note that it says members of the Florida Bar shall not engage in unprofessional conduct. Unprofessional conduct means substantial or repeated violations of the oath of admission to the Florida Bar, the Florida Creed of Professionalism, the Florida Bar Ideals and Goals of Professionalism, the rules regulating the Florida Bar, or decisions of the Florida Supreme Court. Now, you will note that there's no reference there to the Code of Professionalism expectations. And that's merely because the administrative order creating the standard of professionalism was rendered in 2013. The Code of Professionalism expectations were adopted in 2015. Well, the Supreme Court has corrected that so that in 2015, its administrative order was amended by substituting for the Florida Bar Ideals and Goals of Professionalism the Code of Professionalism expectations. So now we have these rules regulating professionalism. You've got the professionalism expectations, you have the oath of admission to the Florida Bar, you have the Florida Bar Creed of Professionalism, you have guidelines for professional conduct, you have the Supreme Court order code for resolving professionalism complaints, which was, as I say, amended 2015. The Florida Bar Ideals and Goals of Professionalism are really no longer a part of the standards because they've been supplanted by the Code of Professionalism expectations, where you have the rules regulating the Florida Bar and decisions of the Florida Supreme Court. Talk a bit about professionalism expectations. Keep in mind that professionalism is really an aspirational term. Ethics are mandatory rules. Ethics are really minimal standards that we as attorneys have to meet in order to practice. Professionalism expectations are aspirational, but I'll mention later that you can become so unprofessional that it becomes a breach for which you might be sanctioned at some point in time. When the code was drafted, there was a debate among the committee members as to whether all the expectations should be mandatory, or some should be aspirational and some should be mandatory. So the structure that developed was this, and these are merely examples. You notice the first, a lawyer should avoid the appearance of impropriety. The word should is aspirational. That's something we should do. But when it comes to the next one, a lawyer must maintain and preserve the confidence and private information of clients. That is mandatory. And the reason it's mandatory is that is coextensive with a rule of ethics. So if you fail to maintain and preserve the confidence and private information of your clients, you're not only unprofessional, you're unethical. The next couple of examples are similar. A lawyer should abstain from rude, disruptive, and disrespectful behavior. The lawyer should encourage clients and support personnel to do the same. Compare that to candor and civility must be used in all oral and written communications. In fact, I think many people are surprised on this one. We tend to think of candor and civility as professionalism concepts, but you'll find that they're also embodied in our canon of ethics. So when we are operating without candor and operating uncivilly, we're not only acting unprofessionally, we're also operating unethically. Then the last two examples I'll let you read, but the point is that the professionalism expectations, when you read them, by looking at should and must, you'll determine what's coextensive with breach of ethics and what is merely aspirational.
Howard, is this a good time to insert a question? We actually had one that relates, I think, to some of what you've just talked about, and that is noting that civility is lacking. How do we get it back?
Yes, I think it is. Difficult question. First, on a societal level, I'm not sure that we can put the genie back in the bottle. Every day, it seems that we descend as a society further and further into the abyss. Our entertainment consists in television of two talking heads taking two sides of an issue and two sides only, totally omitting any potential for shades of gray and trying to drown one another out. Lawyer interviews on TV tend to characterize every issue as war, and the political climate, I don't need to tell anyone, has become more and more toxic. In short, on a societal level, I fear we've lost the ability, and maybe irretrievably so, of thinking analytically and debating respectfully. As lawyers, maybe we need to begin with our education process, certainly in law school. And I can tell you from serving on the standing committee for professionalism that there is a great effort now being made to teach professionalism in our law schools. There are courses, there are formal courses, there are seminars, there are presentations. So there is an effort being made, and in some of the younger attorneys that I deal with in mediation, it may be paying dividends there. But I think we need to return to the principle that law is a high calling. We are officers of the court, and we have a paramount duty to the legal system. So often I see attorneys who seem to have no concept of that. So many attorneys think that effectively representing their clients means adopting a discourteous, uncivil, sort of scorched earth approach. So hopefully I'd like to think that as lawyers, we can maybe lead the way back to civility. And while I'm on that, and while we're talking about those interested in further reading, there's another book I should have put up here. It's Emotional Intelligence by Daniel Goleman, Goleman, 1995. We probably need to start teaching emotional intelligence in our schools. Redefining Professionalism, Florida Code Mandating Aspirational raises challenging questions, the Rizzardi article. You might find that an interesting reading, although it predates the Code of Professionalism Expectations. A lot of lawyers don't know that the Florida Bar has a professionalism handbook. that's available through the Henry Latimer Center. And then one case. This is a case where unprofessional conduct finally rose to a level that resulted in sanctions. The Florida Bar v. Norkin case. It's a real cautionary tale that I would recommend to everyone's reading. And lastly, the quarterly issues of the Professional online. And we as mediators are in a unique position to see the bad, the good. Well, actually, I need to back up. I missed a slide here that I really want to. Yes, how did we get here? How did we get to a point where we have a maze of rules, codes, expectations, committees, commissions, panels? How did we get so complicated on a subject of what amounts to almost courtesy and civility? Well, I published an article on this not long ago. The first, I think, is the law of large numbers. When I began practicing, there were less than 300 members in the Orange County Bar Association. And even then, we had one or two attorneys who were unprofessional. But because they had to deal with the rest of us on a day-to-day basis, peer pressure tended to mitigate their bad behavior. But now we have so many. I don't know the exact number now just in the Orange County Bar Association, but we have thousands and thousands of attorneys in the state, so that just for the law of large numbers, as a percentage of the whole, we have more lawyers who act uncivilly. And there tends to be a diminution of peer pressure and a diminution of judicial intervention, because the bad actors don't deal every day with the same attorneys, and they don't deal every day with the same judges. A judge, when I began practice, would see the same attorneys over and over. So they learned very quickly which attorneys were unprofessional, and they tended to take a hard line with those attorneys to help keep them in line. Now, if you have an unprofessional attorney, a judge may see that attorney maybe only once in 2 or 3 years. And under circumstances like that, the judge tends maybe to view their behavior as a momentary aberration. So you don't get as much judicial intervention as you did. Of course, we now have the argument culture, where everything is a debate between polarized extremes. The increasing speed afforded by technology has contributed to the problem, because now people can write a nasty email and hit the button without thinking and send it off. The other attorney does the same thing, and you have an escalation of unprofessionalism. Today, you also seem to have an increased competitiveness and win at any cost mentality. There's less mentoring today. At one time, most attorneys entered the practice through a law firm, either small or large, and they were subject to a good deal of mentoring from the other people in the group. We now have more and more attorneys leaving law school and opening their own office, so they miss that mentoring. Plus, I see a general decline in communication skills. I've been a mediator since 1996. I've been a full-time mediator since 2003. And I've seen literally thousands of attorneys serving as negotiators in the negotiation context. One of my goals today is maybe to share with you the attributes that mediators observe daily in the really great negotiators, and explore what professionalism means in the context of negotiation. I can tell you that there are some attorneys, some negotiators, who routinely get great results for their clients in mediation. And they do that because they are really professional. So professionalism does pay dividends. A general principle from the Florida Bar Rules of Professional Conduct: as a negotiator, a lawyer seeks a result advantageous to his client, but consistent with requirements of fair dealings with others. Principle number 2, again from the Florida Bar Rules of Professional Conduct: in all professional functions, a lawyer should be competent, prompt, and diligent. And the last, a lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. And this brings us to some of the things that we as mediators have observed. The truly professional negotiator, whether it be an attorney or a claims person or whomever, knows that negotiation is persuasion, and that we don't persuade by intimidating, badgering, shouting, insulting, degrading. The good ones know, almost instinctively it seems to me, that they don't have to be disagreeable in order to disagree. And one of my favorite quotes from Bob Wolf on friendly persuasion: I'm going to tell you the real truth about negotiation. It's not about going to war. It's about talking, not screaming. Negotiation is the respectable art of persuasion between two parties, whether the person on the other side of the table is Henry Kissinger or your local used car salesman. Talk a bit about Bob Wolf's friendly persuasion. If any of you are really interested in becoming great negotiators, and I suspect everyone who's listening is, I highly recommend to you the Bob Wolf book. I've read dozens of books on negotiation, and this, I think, is the one go-to book that I would recommend to anyone. Wolf was, I don't know if he's still alive, he may still be, but was a very prominent negotiator. He represented Larry Bird, Doug Flutie, Vinny Testaverde, John Havlicek, Gene Shalit, other famous people. He negotiated with people like Ted Turner, Donald Trump, Roone Arledge. So very experienced. The book was published in 1990, and the last 3 chapters contain 101 principles or tips for the negotiator. And I really regard it as just a basic book on negotiation. The good negotiator knows that negotiation begins the first time they contact the other side. One of the biggest problems I see at mediation is that the attorneys began early in the case, being discourteous to one another, beating each other over the head with every tool they could find, so that by the time they get to mediation, they are bitter enemies. So the first thing we have to do in mediation is try to overcome that just huge outpouring of animosity and distrust that exists. I can tell you that the really good negotiators know that by the time they get to mediation or formal negotiation, their adversary has to respect them. And when you get 2 attorneys who come to mediation with that same mindset, the cases almost seem to resolve themselves. And the good negotiator is always totally prepared. They come to the negotiation, they know all the facts, the issues, and the law. Nothing can be more destructive of a negotiation session than for one of the negotiators to misstate a fact or an issue or the law. As a mediator, I'll go into the first caucus after the joint session and I'll have someone say, well, that idiot, he doesn't even know what the case is about. And that's very destructive. So the good negotiator leaves no loose ends. They're not lazy or careless with their statement of facts, issues, or law. They're always prepared to field the other side's inquiries. And equally important, they have thoroughly informed their clients of all the risk of the negotiation and the mediation process. They've avoided creating any unreasonable expectations in their clients. I remember one case I mediated where the attorney had been telling his client for months that their case was worth, I forget the number, but let's say $1 million. Obviously, even the attorney, once we got into the mediation process, realized that was totally unreasonable. But he had been telling his client that so long that it was impossible for him or me to have them see anything but the large number he had put out there for them. Good negotiators adhere to the golden rule. They deal candidly and fairly with everyone, and they expect that everyone's going to deal candidly and fairly with him or her. They command dignity and respect by exhibiting dignity and respect. And they never make an unauthorized commitment. And another thing I think that attorneys sometimes lose sight of is that it's not enough just to be honest and candor and fair dealing in this case. You have to have over time developed a reputation for honesty, candor, integrity, and fair dealing. Attorneys talk amongst themselves, clients talk among themselves, and you have to have a character that travels with you in order to be a good negotiator. A good negotiator doesn't expect capitulation without negotiation. But they know that perceptive people are not going to communicate with them unless reciprocal risk take place. Occasionally you'll encounter a negotiator who comes to a mediation and they want all the information that they can get from the other party, but they don't want to give the other party any information at all. And obviously that shuts down the flow of information. One tool I see really good negotiators use is to tell the other party, look, I need some help on this. Could you help me? Could you tell me about this? It's amazing how successful those four little words can be. And they understand the value of incremental movement and time investment. Another problem I see with inexperienced negotiators is that they want to come in and simply say, this is our position. We don't want to waste all day. If you can't do this, we're done. Obviously, that's not negotiation at all. One reason that negotiation works is that people invest time in the process. And the more time they invest, the more reluctant they are to leave without a deal. That is a basic principle of negotiation. And good negotiators know that, so they're patient. They also know that putting out a number is a take it or leave it number. Certainly early is counterproductive because they understand that incremental movement, again, as people move in small movements, they're investing in the negotiation process. Good negotiators are careful of their voice and language. There's no rough, loud, or profane language. They're refined, self-deprecating humor. And on the subject of humor, I think good negotiators realize that all humor, every joke is at the expense of some person or some group of persons or some situation. So they're very careful with how they use humor. Certainly no crude or profane humor, although I have heard attorneys in mediation use, how should I say it, words that I would not even feel at liberty to mention in polite or company. They always have a pleasant voice. They're always polite. No demands. Demand, from a communication standpoint, good negotiators do not make demands. They offer proposals or suggestions. And it's a basic principle of communication. People do not like to have demands made of them. I always sort of grimace in a mediation opening statement when the plaintiff's attorney starts saying, our demands are. How much more palatable are things like proposal, suggestion, or I think this is what we ought to do today. No ultimatums, no take it or leave it. The problem with ultimatums and take it or leave it, I see some people use this very thoughtlessly. If you draw a line in the sand and you tell someone they should not step over it, it seems to me that you need to consider very carefully what you're going to do if they step over the line. So the language, take it or leave it, of course, is counterproductive. But even when you get to that point in a mediation or a negotiation where you do have to put your final number or your final proposal on the table, there are things you can do to clothe it with finality without adding in corrosive words like take it or leave it or ultimatums with it. Well, gosh, this is the best we're going to be able to do today. Or we worked very hard to get to where we are today. We really would like to resolve this case, but sadly we've reached a point where we can't move any further. There are things you can do to clothe it with finality without attaching to it counterproductive terminology. No, I'm insulted. I often like to tell people, I'll sometimes hear a plaintiff's attorney say, I'm insulted. I always like to tell them, if every time I bring additional money in here, you're insulted, at the end of the day, you're improving nevertheless. Good negotiator always remains calm and cordial. They don't whine. They don't get emotional without a goal. And I say without a goal, and I add that deliberately. I have seen skillful negotiators shed a tear in some emotionally charged case, but they do that with a goal, and they always do it under control. They never lose control of their emotions. Good negotiators never take things personally. They never show anger. They don't raise their voice. They always maintain a positive, I'm here to make a deal attitude. And it pays dividends. There's one attorney that I've dealt with over the years in another part of the state that is always remarkable because on more than 2 or 3 occasions, I've gone into a caucus after the joint session and had the other party in a case involving this attorney say, and I won't use his real name, gosh, Mr. X is here today. He's a real pro. Maybe we'll get something accomplished. That's the type of reputation that really pays dividends. And I can tell you this attorney always gets great results for his clients because the other people view him as a real pro. The real pros cultivate a spirit of cooperation. And as I said before, they've developed a reputation for honesty and integrity and candor. They exhibit compassion. They acknowledge the human side of the problem. For instance, an example, some of the good defense attorneys I know, I often mediate medical malpractice cases. And I've heard good defense attorneys say, Miss Jones, I know you've suffered a terrible loss. And although no one in this room can possibly fully understand your loss, we do know that you've suffered a loss, and we're sorry for that. Good mediators don't violate their adversary's trust because it's too hard, one, to squander. They're self-effacing. They leave their ego at the door. They understand who's making decisions in the other room. I can tell you when you enter a mediation that one thing you're going to want to know and you're going to have to figure out is who is the decision maker in the other room. If you're the defendant, who's really driving the train in the room with the plaintiff? Is it the plaintiff or is it the plaintiff's attorney? If you're the plaintiff, you want to know, well, is the attorney driving the train in the defense room? Is the claims person? Who exactly is making the decisions? Now, I have to warn you, the mediator can't tell you who's making the decisions. You'll have to figure it out, but the good negotiators have a real talent for doing that. They understand the role of the mediator. Still, early in the mediation process, back in the 80s, when we first began mediation in Florida, it was generally thought that the role of the mediator was to bludgeon the other party into submission. We've become a little more sophisticated than that, but still occasionally you'll find someone who thinks the mediator's role is to bloody the opposition. That obviously is not the case. The mediator's there to serve as a communicator, an aid to communication, and someone maybe to assist in the problem-solving process. Good negotiators actively listen. And not only do they listen, they give visible and audible signs of listening. They maintain eye contact with the person that's talking. And occasionally, oh yes, okay, when you hear those words, those actually are words in the science of discourse analysis that serve a function. They serve the function of letting the other party know that you are listening. They don't interrupt. One of the worst things you can do is in the negotiation process is to interrupt. When you do that, you're telling the other party that you're not really interested in what they have to say. Sometimes it's really painful when the other party is rambling on to sit there and let them ramble. But a good negotiator knows that that's sometimes necessary. Good negotiator doesn't denigrate the other side, and they understand the concept of venting in face. If you're negotiating a case, your ability to settle that case may depend upon your allowing the other side to vent, to get it off their chest, so to speak. And you certainly don't want to damage their face, their self-esteem. Good negotiators avoid overstating or misstating their case or overreaching and losing credibility. So many times I have, and I think I alluded to this earlier, I have seen an attorney in the opening remarks misstate facts, misstate law, mistake issues, and they simply lose all credibility in the other room. One thing I've heard on more than one occasion, after an opening statement where the one attorney has misstated everything you can imagine, I go as a mediator into the other room and they say, now you know why we're having to try this case. Go to trial in this case. They're patient of other people's foibles in the pace of negotiations, and they certainly know how to control or resist the uncontrollable urges. They don't gloat or brag when successful. One thing that is so important is, as attorneys, we're going to be negotiating tomorrow and next week and next month with some of the same people. And if we gloat or brag when we're successful, that's going to get passed around and it's going to come back to haunt us. And they don't burn any bridges that might lead to future negotiation. You don't always settle a case in one negotiation session or one mediation. Oops, what happened? Did we lose something?
I'm not sure. We may have started back at the beginning, yeah.
Well, let's go ahead a little here, April, will?
Yeah, I think we're at slide 32, Howard.
Okay, we'll get there.
Mm-hmm. I think go back one or two.
Yeah, okay.
There we go.
Okay, there we go. They don't, so in that one negotiating session, that may not be the last one you have. So I think it's important that you don't burn any bridges in that session. And then, by the way, when I use the term negotiation and mediation, keep in mind that all a mediation is a mediated negotiation session. It's still negotiation. The good negotiator understands the value of silence. Silence can be a terribly effective tool for obtaining information. As an attorney, when I was taking a deposition or questioning a witness, often I would ask a question, and even after they had ceased to talk, I would simply sit there and look at them expectantly, as if I were expecting them to say more. And 9 times out of 10, they would say more. So the skillful negotiator knows that silence can be a real asset for them. Another reason it's an asset is every time you listen, you get information. The more information you have in negotiation, information is power. The more you know, the better decision you're going to make for yourself. Also, silence can give you time to think and maybe prevent a precipitous and later to be regretted response. It signals thoughtfulness and attention. This is a great dichotomy. It creates intellectual and not visceral opponents. And this is Herb Cohen. This is a delightful little book on negotiation. Herb Cohen's You Can Negotiate Anything. It's the chapter on negotiating the car deal will keep you in stitches. It's almost worth the price of the book. But this quote is from Herb Cohen. The intellectual opponent can be addressed on an intellectual level with factual and descriptive comments. In this climate, despite the difference in the initial viewpoint of the parties, creative problem solving can take place. Compare that to the other quote by him. A visceral opponent is an emotional adversary, one who not only disagrees with your point of view, but disagrees with you as a human being. Once you make visceral opponents, they tend to stay with you a long time, for they are difficult to convert. Avoid making a visceral opponent the way you would avoid a contagious disease.
Howard, this might be a good time to insert another question we received. It simply is, how do you deal with an unprofessional lawyer, and particularly here where you've spoken about the difference between visceral and intellectual opponents? Seems like a good time to consider, how do we deal with unprofessional lawyers?
Well, there's a famous quote that says, you never wrestle with pigs because you get dirty and the pig enjoys it. So my first thing I would say is, don't reciprocate bad behavior. And really, yeah, the next slide really gets into that. I think one of the first things we need to do when we're faced with unprofessional conduct is look for the motive. If we don't understand the motive, we can't fashion a remedy. And if we can't fashion a remedy and we reciprocate, we have really escalated the situation. So I try always to ask myself several questions. First, I ask myself, is the offender retaliating for something I've done, some conduct on my part? If so, then I think we have to ask ourselves, look, do I need to contact this attorney, and do we need to have a discussion? Let me find out if something I've done offended him. Do they realize their conduct is unprofessional? Some people are just discourteous souls, uncivil souls. They probably should not have gotten into the practice of law. Maybe we should have screened them out. But that may call for a different solution. The one big problem you have when you're faced with unprofessional conduct is discussing it with the offender without descending to their level. One of the hardest things we'll ever do is sitting down with somebody who is just basically a discourteous person and just saying, look, we really need to get along for the sake of your client and my client. Let's see if we can't do this a different way. Does their conduct mask uncertainty or insecurity? Sometimes you'll find this sometimes is a real problem with inexperienced attorneys. Sometimes they try to make up with bravado for what they lack in confidence. So, again, you just have to think through, how do I solve this problem? Are they deliberately trying to anger or provoke us? Well, the best way you can respond to conduct like that is just refuse to be angered or provoked. Are they merely a poor communicator? I recently had a situation where an attorney was offering an exhibit in evidence, and she had, instead of highlighting it in yellow, she had simply used a computer-generated block around the part that they wanted to discuss with the witness. The other attorney said, objected to the admission of that because they had altered the document. Well, I'm sure the attorney didn't mean it the way it sounded, but the word altered, the attorney who was offering the exhibit took that as an accusation of unethical conduct on their part, and before you know it, you have this escalating situation, which I think really sprang just from a poor choice of words. How much experience do they possess? Do they have a basic misconception regarding what constitutes zealous client representation? I don't know. What you might. This would be a good place to go to the Henry Latimer Center, I think, and look at some of the articles on professionalism. In the Professional, that digital newsletter, there are almost always one or two articles on subjects just such as this. How do you deal with unprofessional conduct, or tips or motives? I've written several of those myself. And I think you would find maybe some insight there. Every situation is different. I think modeling for people. I learned from my wife, who was a teacher for years, that you sometimes you need to model good behavior. Maybe by exhibiting professionalism, maybe, just maybe, it might wear off on the other party. I guess if all else fails, you're either going to have to list the aid of the local professionalism panel or the attorney consumer assistance panel. But maybe somewhere down the road, if we all model for these people, maybe it will change their perspective. We can only hope. People tend to act with reciprocity and to behave the way you behave and the way you expect them to behave. And then a quote from one of the articles I published in the Professional. A lawyer's professional reputation is a fragile thing. Once damaged, it is very difficult to repair. Damaging conduct remains in the collective memory of our colleagues and clients long after we have taken corrective actions, thus making repairs a long-term and challenging task. I recently ran into a member of the local bar association. Keep in mind, I've been practicing since 1971 in a physician's office. And I've not seen this attorney probably in 30 years, but my first thought was how nasty he had always been, how unprofessional he had always been. And that was this person's reputation throughout the local bar association. And then I thought to myself, putting it in the context of professionalism, how sad that my overall impression of him, even after all these years, had been colored by his conduct as a lawyer. So it's a very difficult thing to repair. And it doesn't take many. You don't have to be a repeat offender. One incident can be enough to make you have to climb out of a deep hole. Bob Wolf, when you are creating a balance sheet on which to judge the issues, you should give strong consideration to reputation, motivation, production, success, camaraderie, style, trust, compassion, honor, and respect. All the components which offer you dignity. You may find that some things are worth more than money. I've always thought that was a great aspirational quote. And some additional good reads regarding negotiation. The Joan Mulholland book, The Language of Negotiation, is a rather technical book on the subject of discourse analysis. Discourse analysis is the science of the way we communicate. And probably it's the best book available on the use of language in negotiation. Now, it's not a cheap book. It's expensive at about $90, although I think now it may be available in paperback at something closer to $35. I do tell you it is technical, but it provides a lot of insight into how we communicate affects negotiation. Then there's the Deborah Tannen book, The Argument Culture, Moving from Debate to Dialogue. You may remember Deborah Tannen. I think she wrote the book Women Are from Venus, Men Are from Mars, or something to that effect. But in this, she offers a good deal of insight into our culture. It's published in 1998. I can only imagine what she would say if she were writing it today in our present climate. But we tend in our culture to approach everything as if it were a fight. So it's a good look at the two-sided orientation and how it affects us. Bob Wolf, we've talked about. Herb Cohen, we've talked about. This particular book by Herb Cohen, Negotiate This by Caring, but Not That Much, is a fun read. Sort of tongue-in-cheek, a look at negotiation. And then I'm sure most of you have heard of Roger Fisher and William Urey's book, Getting to Yes. It's a good book on the theory, I think, of negotiation and the underpinnings for negotiation. Although I still think Bob Wolf's book is a better nuts and bolts book.
Howard?
Yes.
I was going to say, before you jump to the last slide, if you could go back to the previous slide, we had, yes. I think we've got time for a couple more questions, but I did want to comment. Thank you so much for your insights. You jumped in rather quickly at the beginning before I could tell those attendees that don't know of you or know you personally. You were a board certified civil trial lawyer for 20 years, from 1983 to 2003. And as you mentioned, you've mediated since 1996, but you've also served thousands of hours as a mediator, arbitrator, special master, and special magistrate. So you've certainly observed much of what you've talked about today. There is a good question. You may have hinted at one of these earlier, and that is are there any instances where a display of professionalism resonated with you and you deemed it to be quite impactful in a mediation and or negotiation?
Yes. I told you of the one attorney who always seemed to get good results, very professional. One technique he uses, and probably would not work for everyone, but gosh, it's effective for him, is in the opening remarks, he starts by saying, look, I know how you look at this case, talking to the other party, and I know this is where you're going. And let me discuss with you why where you think you're going is not going to work in this case. And then point by point, he goes through, he starts with what they view as their strongest points. And he does it in a very analytical, very professional, very calm, cordial manner. And I've always been impressed by that approach. And certainly I don't suggest it every case because it may not apply, lend itself to every case. But I always have thought that was a really good approach.
That's excellent. I can think of situations where, something we don't think of often, but being clear to focus on problems and not people. When we go to the negotiation table, whether it's a mediated negotiation or not, I think in terms of the use of language, focusing on the issue, the problem, as you mentioned, the situation with this particular lawyer who does a very clean, analytical discussion of why what you think about this case, doesn't work, again, but not sinking to the level of personal attacks and or talking about the persons, but focusing on the issues, I think always rises to the level of professionalism in a negotiation?
Another example that I can think of that really impressed me was mediating a case. We were doing it in the attorney's office, one of the attorney's offices, and it was a probate case. Probate cases tend to be the very nastiest cases that I find as a mediator I have to deal with. But the one party kept saying in our private caucuses, I'm going to go out to my truck and get a gun and kill that SOB. And after about 3 times, his attorney and I said to him, look, if you continue to say that, we're going to have to call the sheriff. You know, we just can't do this. And then the attorney and I talked privately, and the attorney told me, well, look, he's a diagnosed paranoid schizophrenic. And then the attorney had a spark of insight that I have always admired. He said, you know, maybe we're not talking to him the way we should. So we went to the attorney's office, we got online, and we started Googling how you communicate with a paranoid schizophrenic. And up until that point in time, we had, of course, done what you usually do. We would look him in the eye and talk with him in a serious manner. And but what we found, I don't even know whether it's accurate or not, but it certainly worked in that case, is the sites we found suggested that you sit beside the person instead of across from them to minimize confrontation, and that you sort of look at the opposite wall, the same wall they're looking at, and talk obliquely with them. And lo and behold, we did that, and we got the case settled, and there were no more threats of shooting anyone. So I always thought that was very professional on that attorney's part to think through that mode of communication, and it works so well.
That's a good instance as well, because, you know, I think it's been said one of the greatest illusions about communication is that it actually took place. And so, you know, in any situation, being able to assess the success of whether or not the other side is actually engaged and receiving what you're attempting to communicate seems to be a pretty valuable undertaking.
Another tip for negotiators that people don't often think of, often we negotiate by telephone, probably less so today with the advent of mediation than we used to. But just some tips on telephone negotiation. If you're going to negotiate by telephone, rule number 1 is you be the caller, because you will have had time to prepare your thoughts ahead of the call. The other party will not have done that. So you have a bit of an advantage when you're the caller. And always do it at a time when you're free from interruption. Do, of course, be courteous. If the other side's not prepared to discuss it, then certainly don't. But if they seem prepared, then no reason not to move forward. The other thing, if you're going to hang up, and this gets back to how you deal with unprofessional conduct on the other party. If you're going to hang up on a party, do it during the middle of your conversation. That is, hang up on yourself, because that looks like you've lost the connection. So I'll share that just as sort of an added tip. Well, I think we've probably covered everything we need to do today. Let's get to the last slide here and let you do what you need to do, April.
Thank you, Howard. And I appreciate that comment on hanging up on yourself, because at least you haven't burned the bridge and you can always pick up and call another time. Well, thank you to all today's attendees. Howard, thank you so much for your insight. For those of you who are attending by computer, you see our final slide contains the Florida Bar course number. A number of you have called in, and so I will give you that number now. The number is 180-5347, N as in Nancy. Again, the Bar course number is 5347N as in Nancy. This course is good for 1.5 hours of general credit and 1 hour of professionalism credit. We are hoping to do a webinar each month. I think today's webinar has given us some additional ideas of topics that we may want to present on in the future, but if you have some topic suggestions you'd like to send to either myself, April Walker, or today's presenter, Howard Marsee, please shoot us an email or give us a call at our offices at Upchurch Watson. And again, we have really enjoyed presenting this ongoing webinar series with the University of Florida Levin College of Law Institute for Dispute Resolution. We hope you enjoyed it as well. Thank you so much for attending. And again, check your inboxes for information about our future CLE offerings. Thank you so much.